Good afternoon, and welcome to the 2022 Lander Constitution Day event. It was shortly after the events of 9/11 that Congress, in a desire to stimulate patriotism, devotion, rekindle appreciation of our system, passed the Constitution Day Act. And then in 2005, the Department of Education, being an executive department, enacted a rule implementing Constitution Day. Constitution Day is September the 17th. That's the day that the remaining delegates of the Constitutional Convention signed the Constitution. Hence, it was declared Constitution Day, September the 17th. And the Department of Education, when they enacted the rules, that every school that receives any form of federal funding must, on or near September the 17th, have a program that honors and educates and informs about the U.S. Constitution. And Lander has complied happily and willingly with that since 2005. This is our 17th Constitution Day event, and it's going to be a special one with a very special guest, an alumna of Lander University, who will share her thoughts. And to introduce our guest, would you please welcome Dean of the College of Behavioral and Social Sciences. You know him, you love him, Lucas McMillan.
Thank you very much for coming. It is my pleasure to bring Kierra Brown, a 2014 alumna of the university, back to campus. In 2010, I met Kierra, and she said emphatically that she wanted to be an attorney. And I believed her. And she has stayed with that passion, that curiosity, that excitement for life ever since we first met. Some of our faculty in the audience today had the pleasure of teaching Kierra when she was a student. We were excited and delighted to mentor her, and she went on to take full advantage of so many things at Lander. She participated in the Honors College curriculum. In 2013, she spent a semester in Washington, D.C., where she interned at the U.S. Department of Justice. And she came back from that experience and she said, I want to be an attorney. And I said, great. And she said, and I think I want to go to Penn State for law school. What do you think about that, Dr. McMillan? And I said, it sounds cold. And she said, well, they tell me that Penn State is good, and I think I'm going to apply. And I said, well, you go do that. And Penn State, like the University of South Carolina Honors College that sponsors the Washington program, saw in Kierra the same things that we had always seen, which was academic aptitude, vigorous curiosity, excitement, and competitive spirit, and just a fun person to be around. And so she went to Penn State, and at Penn State she earned the Cali Award in the Professional Responsibility course, and she participated in the Children's Advocacy and Civil Rights Clinics. And then she joined the Mid-Atlantic Black Law Student Association's Thurgood Marshall Moot Court competition, and she and that inaugural team placed as semifinalist. Now, she graduated from Penn State, and then she decided she'd come back to the South, and so she studied for the bar and was admitted to the South Carolina bar, and then joined a firm in Columbia, where she practiced insurance and education law. And then for the past 3 years, Kierra has practiced in the medical malpractice and general liability group of the law firm in Charleston, Copeland, Stayer, Bolts, and Lubbock. And so we are excited to welcome back one of our own, one of our star alumni of this college and of its programs, and we look forward to her remarks. And so as Kierra makes her way to the podium, I'll tell you a little bit about our plan. Kierra Brown will talk about the Constitution and what it means to her, to us, and our future. And after she does that, she'll come back here, and I'll ask a few questions to get us started. But then we want you to be thinking about your own questions and to be thinking about coming to the microphone there in the auditorium so that we can engage in Q&A together. So without further ado, please help me welcome Kierra Brown.
Well, good afternoon, everybody. Thank you for coming out. like Dr. McMillan said, we'll be talking about the Constitution, what it means to you, what it means to us and the future, and more specifically, my thoughts and my views on certain things. So we will get started. I think. There we go. So first, I just want to talk to you guys about why we need a government. Why do citizens, why do free people, free and equal people need a government? Now, if we talk about John Locke is a famous political philosopher. He's pretty well known and has been pretty involved in developing the theory, the social contract theory. He's from England, 1632 to 1704, that's his life. And his belief was men are essentially naturally free and equal. And people have certain inalienable rights, and you might remember this line from the Declaration of Independence. People have the inalienable right to life, liberty, and property. We of course know that as life, liberty, and the pursuit of happiness. So that's what he believes. And so sometimes individuals decide that it's better, it benefits the public good better for them to, in exchange for some of their rights, to have an institution or a government in place that can guarantee stable and pretty happy lives. So in exchange, the government promotes the public good. That means they maintain infrastructure, they protect individual rights, they promote an education system, they assist the elderly, the disabled, the poor, things like that. So that's Locke's belief. Locke believes that all citizens free, equal, but a government would just help and promote the public good better than any individual could. So, with that being said, there are different types of government. Our form of government is not the only form. It can be a monarchy. You can think back to Great Britain, rule of a king. And then there's a monarchy with a law-making branch, and that would be Great Britain. Somehow transitioned from just being a sole monarchy to having a monarchy as well as parliament with both branches having a sort of power. Then there are oligarchies. That's where a group of individuals make the decisions for the government and things like that. Then we have a pure democracy. I'm not sure if you guys know, but we are actually not in a pure democracy. We are in a republic, meaning we vote on representatives who vote on everything else, or most everything else, a large portion of it, let's put it that way. And that's because we as citizens, we don't have time to vote on every issue that can come up. So what we do is we vote on representatives who are able to, as a full-time job, to try and make decisions which are in the best interest of the entire public. And that's when you see elections make a difference, when a group of citizens feel like this representative didn't make decisions for the public good that way that I would expect. That's when you have that turnover in office and those changes. So in the Western world, the default is actually a republic, not a pure democracy, just to let you guys know. Okay, now before the Constitution, America actually declared independence in 1776. The Constitution itself was not adopted until 1787. What did we do in between? There was a whole nother constitution. It was called the Articles of Confederation. And in that document, there was a federal government, there was a central government, and the states still existed, so there were 13 of them at the time. And the way I see it, that document kind of just evidenced the states just saying, okay, we'll be related. Okay, if people lodge war against one state, we'll help you out. But they didn't really have anything that really bound them together. And that is why that Constitution was only in effect for about a decade. The central government just did not have the power that it needed to tax, the power to collect debts, pay their debts from the wars, and certainly no power to really enforce laws and get the states on one accord. So, let me back up a bit. There was a reason for that, and that's because these delegates, the delegates from the states who got together to create the Articles of Confederation, They feared a tyrannical government. You gotta remember, this is immediately following the Revolutionary War. And the reason for the Revolutionary War, our folks in America felt like the government of Great Britain the monarchy had become tyrannical. It wasn't fair. So that's why these Articles of Confederation were very loose. They were it just didn't have a lot of force behind it. So long story short, we have to do a constitutional convention, and there's a challenge because the fear of a tyrannical government is still pretty normal. It's still in the front of their minds. And so the challenge is defining the federal government specifically, but expansively enough to deal with unknown things that could happen in the unknown in the future, unknown possibilities. But also preventing it from becoming all powerful and becoming a tyranny or just a source of power that you didn't want to deal with. So the powers of the federal government are to tax, make and carry out laws, and preserve individual rights. Those are like just inherent powers. And in doing that, the Constitutional Convention created unique features to the Constitution, such as checks and balances, such as separation of powers. That is how they dealt with wanting to make sure it was a broad and powerful central government, but while also limiting the ability for it to become essentially tyrannical. So there are three branches in our Constitution. In the legislative branch, they create laws, including all laws that are necessary and proper. And they also can impeach the president or any sitting judges, federal judges that is. Then we have the executive. He carries out law, or as put in the Constitution, he executes the law of the land. He vetoes any legislation. He has the ability to veto any legislation that Congress presents to him, and he is in the position to appoint federal judges. And then we have the judicial system. The judicial system interprets and evaluates federal laws, the Constitution, and there are other caveats, but we'll get into that. So, the Federal Judiciary. Now, one thing about Article 3 of the Constitution, that's where the Federal Judiciary is defined, it only actually mentions the Supreme Court. Now, we all know that the federal court system is comprised of federal district courts, courts of appeals, and then the Supreme Court. And all judges have lifetime appointments. So that is a fail-safe mechanism of the Constitution, is the fact that that's how they maintain their impartialness. Because they don't have to worry about an election. They don't have to worry about being impeached for their actual understanding and interpretation of the Constitution. So then we have state courts. State courts is a completely different ballgame. It is not mentioned in the Constitution at all, and it's actually one of those leftover powers that are left to the states, because the federal judiciary only has the ability and the authority to hear certain laws, hear certain cases pertaining to specific laws, such as any federal acts, such as the Employment Discrimination Act or the Americans with Disability Act, things that are actually connected with acts that have been prescribed by Congress. And then the federal judiciary also has the ability to make any interpretation or hear any case that is related to the actual Constitution. And then there is another caveat, which actually allows them to hear cases that are pertaining to state law. And that's when those cases have any inkling, any connection to a federal or constitutional right. So that is the judicial branch. Now, judicial review. I keep on saying that the federal courts have the authority to interpret and evaluate law. And Marbury versus Madison is the Supreme Court's first case actually establishing that that is its role. That case came out in 1803. And essentially it said, as the judicial branch, as the Supreme Court of the United States, we have the authority in the final stage to determine what is constitutional and what is unconstitutional, whether it is an act of Congress whether it is an act of the president, and whether it is a state law. We get to determine what is constitutional, and we are the final say. Now, when it comes to interpreting the Constitution, there are actually 3 different ways that legal scholars interpret it. Now, there is originalism. That's where they actually look, the scholar looks at the Constitution and thinks about the time that the Constitutional Convention was in place. What were the surrounding communities like? What were they thinking about? What was their intent in using this language and permitting this right? Then we have textualism. Now they kind of do something similar where they actually just try to look at the actual text, but I'm sorry, they're specific to the actual text. They don't consider the times or things like that. They consider actually what is written, and that is all. And then we have those scholars who interpret the Constitution as a living document, as something that is modified, as something that, as times change, as culture change, as society changes, they reinterpret and they make it fit with what we, what the country needs, essentially. Now that's the one I agree with, and I think simply by the fact that the participants of the Constitutional Convention, they knew that they were going to pass a Bill of Rights. I think we all know that the Bill of Rights wasn't included in the Constitution. They listed out the Bill of Rights and then passed it later. And then you have phrases such as, Congress has the ability to enact all laws that are necessary and proper to promote the public welfare. And then you have other clauses that say things like, and the president will have the authority to execute the law. These vague phrases, the fact that they passed at least 10 amendments shortly after the Constitution, it shows that they intended it to change, to evolve and to grow with the nation. So I think that those who interpret it as a living constitution are onto something, to say the least. Then we have the McCulloch v. Maryland case in 1819. And that is actually exactly what I was talking about, where the Constitution actually provides the federal government with certain implied powers. So it's through those clauses that I just mentioned, those broader clauses saying that the president has the authority to execute the law. Congress has the authority to create laws that are necessary and proper. I feel like those are expansive provisions that allow us to change and to grow and to create and promote laws that are continually for the public good. Okay, so now a history of certain impactful SCOTUS cases, SCOTUS, Supreme Court of the United States. We have U.S. v. Darby. This is after Congress had passed the Fair Labor Standards Act. And that's the act that actually got rid of child labor, that enforced a minimum wage. And the case came up to the Supreme Court, and I believe the plaintiffs wanted to say that it was unconstitutional. The court decided it is constitutional. It's constitutional under the necessary and proper clause because it promotes the public welfare. It's better for workers to have a fair and healthy work-life balance. So then we have Brown v. Board of Education, the desegregation of public schools. That was decided under the 14th Amendment, due process and equal protection, where the court understood that although Plessy v. Ferguson is a separate but equal case, the rationale wasn't completely, The rationale wasn't completely incorrect. It just, in application, it just wasn't working out. It was visible, it was apparent, it was objectively real that the school system wasn't separate but equal. So then we have Gideon v. Wainwright, where for the first time the Supreme Court decided that not only do citizens have a right to counsel via the Sixth Amendment, but the government actually has the burden, and it's one of their duties in promoting the public good to actually provide counsel. Now, one caveat with that is we haven't seen, and that's in criminal cases. So in criminal cases, I'm sure you all know, people have the right to counsel, and those counsels are typically public defenders. But one caveat, like I was saying, is we actually don't have a similar law on the civil side of things. Most states do not provide counsel for indigent or poor or less wealthy people when it comes to civil matters, except for another caveat, a caveat of the caveat, if you will. So, except for when it comes to landlord and tenant issues, that is those are one of the cases where the law, most states will allow and provide legal aid or legal services, and that is usually through the legal aid offices from county to county. Tinker v. Des Moines, preserving the rights of students at school. That was a First Amendment case. If I'm not mistaken, the students decided that in opposition and protest of the Vietnam War, they would wear black armbands, and the school somehow or another decided to suspend them for this speech, and the court was clear. Even though they're minors, even though they're underage, they do not shed their rights, their constitutional rights at the schoolhouse gate. And then a few years later, they actually had to decide Bethel. So in that case, the school was wrong for disciplining them for wearing their armbands. That was a form of speech, symbolic. And a few years later, we had a case called Bethel. And in that case, there was actually, so this happens time and time again where the Supreme Court makes a decision and then goes back to refine it as new situations arise. So in the Bethel case, a student, he got on stage, it was a school assembly, y'all, and he starts making all kind of innuendos, if you will, an inappropriate innuendo that was kind of disruptive to the entire assembly. And he decided he wanted to rely on the Tinker case, and say, you know, Judge, we don't shed our rights at the gates. We have the right to free speech, and I had the right to make that speech. Well, the Supreme Court had to decide again, make another decision and say, yeah, you have free speech, but you don't have the right to disrupt the learning environment. So that narrowed that right a bit. Then we have the Roper v. Simmons case, where the Supreme Court found that it would be cruel and unusual punishment under the 8th Amendment to execute a minor. And along those lines, actually in 2017, the Supreme Court actually went a little further. It's the case called Street. And they decided that it was also unconstitutional. It was also cruel and unusual punishment to sentence a juvenile to life without parole. So that was a very big case a few years ago, and it had very big impacts for a lot of people who had been in jail for 50 plus years for being an accomplice or something. Then we have the National Federation of Independent Business versus Sebelius, and this is the Affordable Care Act case. So if you all recall, I believe 2012, Congress passed the Affordable Care Act shortly before this case, and it had two parts to it, two moving parts. One, it required Americans to purchase health insurance. And then secondly, if you didn't purchase health insurance, they would tax you. Or, I'm sorry, they would penalize you. That's the word that's used throughout the act, penalize. And so when this case came up, the plaintiff said it's unconstitutional, you can't force people to buy health insurance, things of that nature. And the defendant, the government, they ended up citing the Commerce Clause as well as the tax clause, so Congress's authority to tax. And the court decided, even though there was not one mention of a tax in the act, they decided it was constitutional because Congress does have the power to tax, even though it doesn't have the power to require people to purchase health insurance. And actually, I want to say in 2021, this case came back around. It was during COVID. The case came back to the Supreme Court where a group of, I want to say, politicians brought the case back and wanted the court to rule it as unconstitutional. And this is one of those living document points for me because during the height of COVID, what is in the best interest of the nation? For people to always keep their insurance, their health insurance, like that's just so obvious, right? So the court actually decided not to even hear the case. They dismissed it on the grounds that the plaintiffs didn't have any standing to bring the case. And it's certain things like that where it's not, that's what our Constitution allows. That's what I can say. And I think that was a good move for them. Like I said, the public good was in continuing to make sure that those 40 million Americans had insurance. That promoted the public good rather than rehashing a case that had already been decided almost a decade prior. So then in 2015, the Supreme Court, I say, legalized same-sex marriage, legalized, recognized same-sex marriage, and that was decided under equal protection due process because of the benefits that the government bestows upon married individuals. It was really no legal basis for them to not allow same-sex couples' marriages to be recognized. Okay, now some recent cases in June of 2022. Now this all starts with the Heller case, where the Heller case actually acknowledged that, or the Supreme Court actually acknowledged and decided for the first time that individuals do have the right to bear arms themselves specifically for lawful purposes such as protecting themselves and their homes and their families. So this New York State Rifle Association case that was decided in June of this year, I believe the New York law had, like I said, it was in New York, and that law articulated that in order for a person to get a concealed carrying permit, not just a permit for your gun, but a concealed carry, they would have to show proper cause. And that's a higher burden than just saying, I just need it for personal protection. The Supreme Court wasn't having it. They're like, that's unconstitutional. The state has to show why this person shouldn't be able to carry, as opposed to the individual showing them why they deserve to be able to. Then we have the National Federation of Independent Business versus the Department of Labor, and that was in 2022. I think we all heard about the mandate that either during COVID, that either individuals got tested or got tested on a daily or a weekly basis, or actually got their vaccine. In this case, the Supreme Court actually stayed the regulation. It was a regulation from OSHA, Occupational Safety and Health Administration, I believe. That's who was attempting to put that mandate in place. And that was going to affect workplaces. So anywhere where there were at least 100 employees, I believe, any employee who did not get vaccinated would have to submit a test on a weekly basis showing that they did not have COVID to prevent the spread. And that's an ambitious goal, that's a respectable goal, but the Supreme Court just decided to stay it instead of actually letting it go into effect because it just wasn't constitutional. Then we have Dobbs v. Jackson Women's Health Organization, decided in June 2022, ruling that women do not have a constitutional right to abortion, and they decided that via the case law and precedents that was developing the right to privacy. I don't know if you guys know, but the Roe v. Wade case, 50 years ago, that decided women did have a constitutional right to abortion, was decided under the inherent right to privacy. And in June 2022, the Supreme Court decided that was not a constitutional issue. They did not say it was illegal to do it. They just said it was not a constitutional right and kind of reverted it back to the states to decide on an individual basis. That is it.
So we're going to now have a little bit of conversation, and I'll ask you to be thinking about what questions you would like to ask. But I'll start with just asking Ms. Brown, tell us your favorite part of the Constitution, or what you like about it, and then if there's anything you don't like about the Constitution, what would that be?
So my favorite part is actually, I decided, it's actually the amendments.
Okay.
Because it supports the idea that this is supposed to be a living document. This is supposed to be a document that transforms and re-encompasses the nation as we grow, as we find ourselves, and as culture shifts. The amendment process just, to me, supports that conclusion that you have to consider the times as you consider the provisions and as you interpret the provisions. I don't think I have a least favorite part. I will tell you the separation of powers and the checks and balances really float my boat as well.
We've had several Supreme Court confirmations in recent years. Do you find yourself ever having a question that you would like asked? You know, the senators on the Senate Judiciary Committee ask questions, but is there ever in your mind a question you wish would be asked of a person who's nominated to the High Court?
No. So for me, I think the Senate does a good job of asking the questions, if not for the cameras, in the background. They ask the questions about the things that we want to know. So for example, I believe one senator, she asked Kavanaugh, before he was ever approved, she asked him his opinion on abortion and what he thought that right looked like. And so I guess I believe that the senators ask what needs to be asked, but I also know that because it's lifetime appointments, you can ask what you want. They got their lifetime to change their minds, you know?
well, some of us, come away from some of those hearings thinking that the senators are asking the big questions that are on the public's mind,
Mm-hmm.
but I guess not always thinking long term.
Mm-hmm.
I'm a person who teaches about international politics, and sometimes I want the question asked, how does American law relate to international law? Or how does international law relate to American law? And certainly the court has, and I bring this up because you mentioned it, they will look at international norms sometimes as part of their rationale.
Mm-hmm.
So the idea of how do you treat a juvenile, and what is an appropriate sentence or consequence and punishment of a juvenile's act. So that's just something to think about. In a globalized society, the reason I bring this up, I think there's going to be more and more interaction between international issues and American law. So that might be something that comes up from time to time. Has your career as a lawyer allowed you to think about the Constitution in different ways, meaning that has your practice of different areas of the law shown you different things about the Constitution, or has your view on the Constitution changed over time?
So no, I've always thought of it as a living document, I will say that. In my practice, unfortunately, I'm typically either state law,
right,
or it's different acts, so like the Employment Discrimination Act, the Americans with Disability Act. I had a couple of cases pertaining to the Establishment Clause, but I haven't had too many cases that actually interact with the Constitution.
Right. And can you tell us anything that you wish you would have known when you were at Lander about the practice of law? So you had all sorts of classes,
Mm-hmm.
and then you went to Washington.
Mm-hmm.
But before you went to law school, is there something that you wish you would have known about the work of an attorney or the practice of law that our students would benefit from?
Well, I'll tell you, a class on how to write like a lawyer would have been amazing. It's completely different. So nothing that I wish I knew, because a lot of the practice of law, it's based on that foundational stuff I learned here. Respond back to an email within 24, 48 hours. Kind of the professionalism stuff, how to kind of interact and discuss different topics, different topics with your elders, with your professors, and kind of talk things through and work as a team. Have good time management. Time management is very important. So try to master it while you're in college.
So I'll be waiting for people to approach that microphone with your questions. So don't be bashful, come ahead. What would you say about the interaction between federal law and state law? Do you have any experience that you could tell us about those federalism issues or the conflict of law or kinds of things? Because you practice some in state and federal courts.
Mm-hmm. So I actually prefer federal court. Any defense attorney is going to tell you something probably similar. The deadlines are tighter, but the legal arguments that you get to make, that you get to kind of argue are just, you can make the same argument in state court, but it just doesn't have the same effect. It's a running joke among lawyers that state court is kind of like a Wild Wild West. Like, good luck. That is a plaintiff's lawyer's favorite place to be, and I understand why. I like a more structured federal court case. And as far as the interaction between the two, I'm always trying to get any case I get. I'm looking to see if I can take it to federal court. Because, I didn't say this earlier, but one other way that the federal courts have jurisdiction is through something called diversity jurisdiction. And diversity is any state court case, any law, and it can be a state law, any law when someone's being sued and there's more than $75,000 in controversy and the defendant is not a citizen of that state, you can go to federal court. And I'll tell y'all, the reason being is because the defendant has some sort of ability. Well, let me actually treat it how I treat it. So basically the defendants are going to argue, oh, we can be prejudiced. We would be prejudiced. They don't understand, usually the defendant is a company, right? But we'll be prejudiced by being in state court by these local people. It needs to be a bigger jury pool. That way it's people who are not so connected to this particular area of the state. So that's how you get a federal court, and I'm always trying now, always.
Is there, well, we've got a question. Yes, sir.
Hey, you doing? Tyler, by the way. How would you say, in what way did you best prepare for the LSAT?
Oh, I bought books. So there are, I went to just a Barnes and Noble, or maybe it was the Books A Million. And I just bought they had all kind of LSAT practice books, and I just studied for a few hours every day. It wasn't anything crazy. You could take a course, there are courses. What I will tell you is, although somehow or another, studies show that how people do on the LSAT does impact how they end up doing in law school, I don't see the correlation, I will tell you that, but that's the thing. But, yeah, just grab some books, you could take a course.
Did you take a logic class in philosophy?
I did. Who was my teacher?
Professor John Moore. Yes.
Was it John Moore?
It was John Moore.
Okay. Was it somebody else?
It could have been Matt Faust.
It was not.
It was Dr. Faust.
Mhm.
Okay.
Mhm. I know I took some more with John Moore, but.
So you took some other philosophy classes.
Mhm.
Yeah. Many students at Lander, if you do the pre-law minor, would talk about philosophy classes, particularly the logic course, because the LSAT.
That is all it is,
Logic
logic.
games.
Mhm.
Logic games. So while we're on Tyler's question, any other courses or experiences at Lander that prepared you well for law school?
So I majored in political science, I minored in economics, so I had a pretty good foundation as to how the government works, how the judiciary works, and things like that. So those are all, of course, encouraged. But I think what I took away the most, what helped me the most, was taking it serious, y'all. Like, seriously, like, I didn't just skip classes, I didn't just skip assignments. I took everything serious. I took everything and gave it my 100% best and tried to improve. So I, like, taking that mindset through life is just, it's a good one to have.
And you, so you went to Washington.
I did.
So tell us about that semester in DC. What did you get out of it? What was your favorite part of it?
It was a bureaucracy. So I actually, we took a few different classes while we were there. So we worked full time. I was at the Office of Juvenile Justice and Delinquency Prevention. I think I was the first intern in that program that went to that office. And when I got there, they were actually in this big reorganization.
Yeah, that's in the Department of Justice.
Yeah, within the Department of Justice.
Right.
So there was a reorganization going on where they were kind of trying to redirect programs, redirect funding. And so I think one of the bigger projects I worked on was, I don't know if you guys know these little boot camp's the wrong word, but you know when they take the kids, scared straight, they take the kids to the jails and like try to scare them straight, I guess. And apparently that actually violated the law. Like any contact between a minor and individuals who are, and people who are, persons who are 18 or older and within jail, that is like completely forbidden. So we had to get the word out to these states because they were losing funding. That's how that office promoted juvenile justice, is by kind of pulling the purse strings. So I got to see that in action. That's a lot of what Congress does. Like they dangle some money and say, we'll give you this money if you follow this rule, and the states usually get on board. But we had these states that were losing their funding for certain programs because they were allowing the scared straight stuff to happen. So I think that's the biggest project that I took part in that had an impact, because yeah, you could walk them through a jail, but you could not, and that would be fine.
Did you tour a prison at some point in that internship?
What did I do? I think did I? I think I did.
So there are, my reason, you may not remember the details, and I don't either. I remember that the internship, like all internships, can be spontaneous, can have these extra, opportunities that you, nor perhaps even the supervisor, initially planned. So I think you were offered a chance to go tour a federal prison.
I'm picturing it.
Yeah.
I think I was. Yeah, I'm pretty sure I was. And when you look at, so that was in conjunction with trying to get the states to stop touring the facilities.
Right.
And so when I saw it, it's the reason I blocked it out, y'all. Let's just go with that.
Right. Dr. Creighton has a question.
I do. I was wondering if you could say a little bit more about how writing for the law is different than writing college papers, and maybe tell us a bit about how much writing you actually do in your job.
Ooh. I write all day, every day. I read all day, every day. Unless I get to go to court. That's like the field trip for me. Oh, I get to go to court this time. So with writing for the law, they call it legal analysis, and there's a specific structure where you start with your conclusion, you then tell your rule, and then you give an explanation, meaning, so the rule is going to be what the court decided, or what the law says. And then the explanation is going to be how the courts have interpreted it in different case settings. So, and then you apply, and when I say case settings, I mean in different circumstances, which factual circumstances. So the way they apply one law to a guy driving a pickup truck and the way they apply it to a guy driving a backhoe truck that pumps water from ditches, that huge 15-ton truck, is going to be different because there are different facts involved. There are different requirements for licensure and things like that. So you, like I said, you want to state your conclusion, you want to state your rule, you want to state how courts have applied it, and you want to find a case that is actually as factually similar to your facts as possible. And hopefully it went your direction, right? And then you want to analyze it under your facts, and then one more conclusion. And the difference in the writing, it's just different. Because there are so many different factors, so many different factual scenarios that the same laws are applied in, and I think that's the caveat. But once you can get a handle on that, like the rest is pretty easy peasy, but I definitely write briefs very regularly, 20, 30 pages. The citations are different than the MLA format that you guys use here. I think that's like the top difference, or at least that's how it happens.
Do you enjoy the research or the writing more?
I like them equally, and I'm gonna tell you because by the time I'm writing something, I figured out how I'm going to win.
Okay.
So I get excited when I find my case, and then I get excited to explain it.
But I assume that all those papers we made you write were somewhat helpful.
Oh, absolutely.
Good.
It's about endurance.
Right, it's about endurance. Good. Okay.
Absolutely.
So one thing that our students sometimes ask, what is it like to go into the courtroom? And, can you say anything about experiences you've had, positive or negative, about the court or judges or working with other attorneys in the profession that would be insightful for our students thinking about the profession as an attorney?
So court is a bit intimidating until you actually start to recognize the faces of the other attorneys, and you won't get to recognize them until you go to court with them 20, 30 times, until you're on email threads with them and chatting it out. But one thing I can say is most attorneys in South Carolina, they really take that oath of civility serious, so they're very kind. Now, not perfect, but kind. That's what I'll say, not perfect, but kind. And very encouraging. I've noticed that just in the legal community, period, very encouraging. I had a case where I was deposing a plaintiff, and I'm not gonna lie to y'all, I was getting hammered. And even then, the lawyer on the other side of the table, she was like, you know what, maybe you should ask it in this kind of fashion. So it's not, even though it's adversarial once you get to court, all the way up into that, you're just working the case with a counterpart, you know what I mean? As far as other court experiences, I will tell you, when I run into some fierce female attorneys who really have found their voice, it is very impressive. And because it's so easy to be disregarded, it's so easy for people not to hear what you're saying simply because you didn't have baritone in your voice or something. And it's more common than you would think, unfortunately. But some female attorneys are not intimidated whatsoever. They are real powerhouses and confident in their knowledge. And I think that comes with time. Like, I know I had one female attorney. I hated having cases with her. She was a plaintiff's attorney. She's nice enough. I did not like having cases with her because it was guaranteed that she would have a roundabout way around what the law actually said. And it was actually more difficult to get out of cases with her. But she was very confident, and she stood in her power and her ability. So it was impressive in that respect because she wouldn't be backed into a corner. So I think, to be honest, just as an attorney, just to have that confidence and belief in your own ability is pretty vital. Other scenarios, I remember I was telling Dr. McMillan about my first time arguing in federal court, I was before Judge Paige Gossett. And it was myself and another attorney, her name was Miss Bowen, I will call her first name. And she and I, we actually had gotten sworn in together. And it was actually our first time arguing in court. So there's two female attorneys, and we've got a female judge, and she has her robes on. And as she's walking to be seated, she has these sparkly high heels. And so Ms. Bowen and I, we just make eye contact because at this point, we're like only a year out of law school. We're like, okay, this is the dream. That's the aspiration, that's the goal. And even during that hearing, she asked the most intelligent questions. It was really, it was a great hearing. It was a great hearing, and I think part of it, I think she understood most of the things she was asking us, but I think she really wanted to give us that experience of arguing back and forth and developing those chops, because you're gonna need them out in the world. You gotta know how to stand for what you're saying.
I was just wondering, through law school and then while you're practicing law now, what did you find that was like the most challenging thing you've come faced with?
The most challenging thing I've been faced with?
Right.
First semester of law school. It's a completely different ball game. You have, I just listed off like a bunch of cases and kind of talked through them with y'all. And it will be the first day of class, and the professor will just look at you, cold call you, and say, you, tell me about Heller v. United States. No context clues, no nothing, and if you didn't do the reading, you can't pick your way through it. So I think that was the most challenging part of it, is just understanding how part of law school it is how much reading you're going to do. I used to easily do 250 to 300 pages of reading per day. And now it's not as much reading, but so now I would say the most challenging part of my job is investigating the cases. Because you have to have all the answers. That whole don't ask a question on cross-exam that you don't know the answer to already comes from all the investigating you're supposed to do on the front end. And so as you grow, as you begin to learn what issues are actually issues in the case, what issues will actually win you the case, what you need this witness to say, what kind of evidence do you need. And it's hard because it's like, how do you know what kind of evidence you need if you don't know what kind of evidence is out there? But thinking of clever ways to find what you need and actually finding it is worthwhile. I'm not gonna lie, I get excited. I'm like, no. Like when you find your point, like when you find what you can hammer home on. I had one case, it was a trip and fall, and it had been going on for like 2 years. And finally I got some medical records, and it turns out that a couple of hours before the trip and fall, she was saying it was too dark outside, so she couldn't see the curve, the curve was too tall. And so I got the medical records in, and it turns out she had been placed under general anesthesia like 2 hours before the fall, and was walking alone, and had already had balance issues. And it's like, ma'am, let's settle this. So that's what we did. It's very rewarding when your investigation actually comes up with something that's going to help resolve the cases. But investigation is challenging.
Can you talk about the dynamics between a smaller law firm and a larger law firm? You were in Columbia, now you're in Charleston. Your firm now has 3 offices, I believe, Atlanta, Chattanooga, and Charleston. Can you compare those 2 experiences?
So they were both defense firms. I'm not sure if you guys know what billable hour requirements attorneys have to. Our work is based on how many hours we bill the client, not how many hours we're in the office, not how many hours we help the staff with something else, but actual hours that we can bill the client for. So that remained the same. I want to say once I went to a larger firm, my billable hour requirement increased. But once I got to a larger firm, I actually so there are different benefits. Let me back up. So at the smaller firm, I always had a senior partner there with me helping me with whatever I was doing. So if it was a deposition, they were there. And you know what though? I don't think they went to that hearing I was just telling you guys about. But either way, they tried to make sure they came to everything and were there to assist me and things like that. But with the larger firms, my senior partner is rarely in the deposition with me. Never comes to court with me. And it's just a different management style. I think it's a more high up view of, like, not so daily check-ins about or weekly check-ins about what you're doing. Mostly, if I would call my senior partner and say, hey, let's do a case review meeting. So I try to do that once a month, let's just put it like that. But I think you just get more independence in the larger firm. But there are benefits, so I'm happy that I was at the smaller firm early on because I kind of got that hand-holding and that one-on-one time with my partners in that case. And I think that really helped me have the confidence that I needed once it was time to go to the bigger firm and do things on my own. Still was a bit intimidating, but we get by.
Well, it's like any professional growth. You get more comfortable. You get more experience. You know how to recalibrate if you make a mistake. I think one of the things an undergraduate student is likely to think is that everything has to work perfectly. And everything has to be smooth. And I think those of us in the working world would say that it's not going to be smooth.
Hindsight is 20/20.
Right.
So those, when you're in the middle of something and it's not working out and things like that, you're like, oh wow, this is just awful, this is just not working, whatever. But then once you are 6 months out from that experience, you realize how it shaped you and got you where you are. Everybody has those hiccups, those challenges, but you get past them. Time cures all, seriously.
I'll entertain any last minute questions anybody has. Or I can always ask more. We've always got more to talk about. Well, let me ask this one last question. The Constitution that the United States has is shorter than most other countries' constitutions. It is no longer the template that a country would use. So if you were to become a democratic republic of some sort, you would not likely look to the United States Constitution as your playmate. Because it seems that most countries in the past 75 years have looked more at a document like the Universal Declaration of Human Rights, which is more of a litany, a list of rights. So we're not the foundational template that I think many Americans think we are for the rest of the world in democratic life. Either comment on that or we have some challenges in American democracy today and some challenges in American political participation. Do you have any thoughts about either the place of the United States as the exemplar of constitutional government in the world, or do you have any thoughts to share about the place of the United States in the example of democratic life and civic life to the rest of the world that you want to share?
Well, share your thoughts first.
Well, she turns it right back around. I mean, I'm a little bit worried about some things. I'll just say on this Constitution Day, I worry about the people in the United States that have low levels of trust in government, low levels of trust in their neighbors, low levels of trust in themselves. And I think that the American experiment of civic and political participation requires a certain level of trust to keep going. And I feel like that has been falling in some years, and I worry about that, which I think I won't speak for my colleagues, but I think there are other people at Lander that worry about that. And I think this is why we try to get students here on a smaller campus to have conversation, to debate big ideas. Because that debate is important. We don't want people to be apathetic. We don't want people to divorce themselves from civic and public life. But there's a way to do that.
I
What do
agree.
you think?
It is concerning, but, and I'm an optimist, y'all. I don't know if you can tell. I just feel like the fact the Constitution is durable. Like, I understand trust and participation is falling, but because it is a living document, because it can be changed and added to, like, there's still a chance. I don't want to say chance, greater than a chance.
Sure.
It's still able to, we can come back from this. That's my opinion. I don't think there's anything that the Constitution can't address for the most part, through an amendment or through any of the clauses or articles. So I think just if everyone can get on one page that it's a living document, that it should be changing, that it should be evolving as we grow and evolve as a nation, I think we can get increased participation, we can increase trust. If it is applying fairly to everybody, if there is less dispute about, oh, let's just think about it exactly the way the framers would have thought about it. We're how many centuries, at least 2 centuries beyond that, right? So I think that is the answer, just kind of understanding it's a living document. It was supposed to be living, and I think the balance is, no one wants the federal government to become all-powerful, tyrannical, and there's that danger, but there's that danger with everything, because at this point, either we're going to allow political participation to just fall to nothing, or we're going to work with what we got and try to continue to grow and develop from there.
Well, I think what you've seen today is Kierra Brown is certainly a pride of Lander University, took advantage of a lot of things while here as a student. Certainly those of us that had the privilege to teach her are not surprised by her success, and we bask in the joy that you're continuing to do good things and represent the university well. So join me, if you will, in thanking Kierra for coming today. I think she's willing to interact and ask questions with you individually after our program. So thank you very much for coming, but I think she'll stay around for questions.